All rise, veuillez vous lever. The International Criminal Court is now in session. Lord John the Court Panel International at 08. Please be seated. Veuillez vous asseoir.
Good morning, everyone. I would like to welcome all of you into this courtroom. Madam Court Officer, could you please mention the case?
Good morning, Madam President, Your Honors. This is the situation in the Central African Republic 2 in the case of the prosecutor versus Mohammed Said Abdelkhani, case reference ICC 0114-0121, and for the record, we are in open session.
Thank you very much. Counsel, can you please introduce yourselves, starting with the prosecution, please?
Good morning, Madam President, Your Honours. My name is Kareem Khan, and I lead the prosecution in this case. I'm joined on my left by Deputy Prosecutor Mr. Mande Nyang, trial lawyer Leonie von Braun, and then behind me we have the senior lawyer in the case, Hollow McQuay. We have Miss Brunhild and also Miss Adriana Rodriguez, and then right at the back we have Ramu Bitier, our case manager, Sanyu Dagire, also a trial lawyer in the case. Thank you.
Thank you very much, Mr. Khan. Counsel for the victims, please.
Merci Madame la Présidente, bonjour. Les victimes dans cette affaire sont représentées par Adeline Bédoucha, Tars van Litzenborg et moi-même, Sarah Pellet, conseil au bureau du Conseil public pour les victimes.
Thank you very much. Defense counsel, please.
Merci Madame le Président. À côté de moi, Dov Jacobs, conseil associé, Léa Alix, et derrière, Maître François Jacquemin, Maître Valduriez et Manon Lancel. Et quant à moi, je suis Jennifer Naori, conseil principal de Monsieur Saïd. Merci.
Thank you very much, Ms. Naori. I don't know if you have any representative from the registry. Anybody from the registry? No? Okay. For the record, I take note that the accused, Mr. Said, is in court. So for members of the public, let me quickly introduce the chamber. I myself, I am Miata Maria Samba, and I'm the presiding judge. To my immediate right is Judge Socorro Flores, and to my left is Judge Sergio Ogalde. As you are aware, we're here today for the opening of the trial of Mr. Said Abdelkhani. For the record, Mr. Said Abdelkhani indicated to the chamber in January that he goes by the name of Mohammed Said. So we will be referring to him as Mr. Said in these proceedings. I will open with a few preliminary remarks, and then the charges will be put to Mr. Said. We then intend to hear opening statements by the prosecution. This will be followed by the opening statements of the legal representative of victims and then the defense. As an introduction, I wish to provide some short background information to this case. On the 30th of May 2014, the government of the Central African Republic referred this situation to the court. This referral pertains to crimes within the court's jurisdiction that may have been committed since the first day of August 2012. On the 7th day of January 2019, the pretrial chamber issued a warrant of arrest against Mr. Said. He was surrendered to the court on the 24th day of January 2021 and made his first appearance on the 29th day of January 2021. On the 9th day of December 2021, the pretrial chamber confirmed the charges against Mr. Said, which are now brought before this court. Today is the opening of the trial. At this juncture, I'd like to emphasize that the chamber is aware of the importance of parties being able to fully present their case. At the same time, we wish to stress that we will expect the trial to be carried out in an effective and expeditious way, not only for the benefit of all participants, but more fundamentally for the benefit of the accused and the victims. We will now turn to Rule 134 of the Rules of Procedure and Evidence. In Decision 243, the Chamber set a deadline of the 22nd day of July 2022 for the filing of any motions requiring resolution prior to the commencement of trial. The Chamber notes Rule 134, Sub-Rule 2 of the Rules. The Chamber will now ask the parties whether, save any pending request with the Chamber, they have any remaining objections or observations concerning the conduct of the proceedings which have arisen since the 22nd day of July 2022, which was the deadline set by the Chamber. Be mindful that in accordance with Rule 134 Sub 2, no such objection or observation may be raised during the trial proceedings without the leave of the court. Mr. Prosecutor.
Thank you, Madam President. No objections as far as the prosecution is concerned.
Thank you very much. Ms. Nauri, I note your email of, you may want to stand up, please. I note your email of Thursday, the 22nd of September, that you do not intend to raise any objections or observations. Could you kindly confirm that for the record?
Merci Madame le Président. En effet, comme la défense a pris bonne note de la décision du 21, la décision prise récemment par email, le 21 septembre, que nous pouvions faire des observations que de choses qui se sont passées après le 22 juillet. Dans ce cas de figure, la défense n'a pas d'observation, puisqu'il sera difficile pour nous de distinguer artificiellement entre ce qui s'est passé avant le 22 et après le 22 juillet 2022. Merci Madame le Président.
Thank you very much, Ms. Naui. So in accordance with Article 64(8)(a) of the Rome Statute, the charges will now be read to the accused, following which Mr. Said will be afforded an opportunity to make an admission of guilt or to plead not guilty. As agreed by the parties and the chamber, the court officer will now read the charges, omitting those portions containing confidential information that cannot be read in public session. Madam Court Officer, can you kindly read the confirmed charges to Mr. Said? Thank you.
Thank you, Madam President. The charges against Mr. Said, as confirmed by Pretrial Chamber 2, read as follows. Regarding the contextual elements of war crimes, Pretrial Chamber 2 confirmed that at all times material to the charges, including from at least March 2013 until at least January 2014, there was an armed conflict not of an international character on the territory of CAR. The parties to this non-international armed conflict were distinguished from one another by factors including their affiliation or opposition to François Bozizé, Mr. Bozizé, President of CAR from 2003 until 24 March 2013, even though their outward appearance, military organization, and tactics significantly adapted as time passed and according to the vicissitudes of war. Thus, forces loyal to Mr. Bozizé initially included the CAR Armed Forces, the Forces Armées Centrafricaines, or FACA, and later the coalition known as the Anti-Balaka, and forces opposed to Mr. Bozizé formed a coalition known as the Seleka, led by Michel Djotodia, Mr. Djotodia. Later, after the Seleka temporarily assumed control over the CAR, pro-Bozizé forces, including FACA members and former presidential guards under Mr. Bozizé, regrouped, rearmed, and reorganized themselves as a broader insurgency that became known as the Anti-Balaka. While the intensity of hostilities between the pro-Bozizé forces and the Seleka varied, at no point in this period was the conflict resolved by a peaceful settlement, such as the complete obliteration of one of the parties or a lasting absence of armed confrontation between them. The conduct that forms the basis of the charges in counts 3 to 4 and 6 took place in the context of and was associated with this armed conflict. At all material times, the perpetrators of the charged acts, including Mr. Said, were aware of the factual circumstances establishing the existence of the armed conflicts. 1. The intensity of the armed conflict. The armed hostilities in the CAR between the pro-Bozizé forces and the Seleka were protracted, exceeding the level of internal disturbances and tensions, such as riots, isolated and sporadic events of violence, or other acts of a similar nature, and sufficient to establish a non-international armed conflict. Specifically, in late 2012, the Seleka launched a military offensive in northern CAR, occupying major towns and advancing southward towards Bangui, the capital of CAR. The FACA and other forces loyal to Mr. Bozizé were unsuccessful in resisting their advance. By 24 March 2013, the Seleka were in a position to assault Bangui and drove Mr. Bozizé into exile. Mr. Djotodia proclaimed himself the new president of the CAR. From 24 March 2013, Mr. Bozizé and his allies rapidly regrouped, rearmed, and reorganized to strike back against the Seleka. This led to the formation of the Anti-Balaka coalition, which combined elements of the FACA and the Presidential Guard with pre-existing and new self-defense groups in the CAR. By September 2013, within 6 months, these forces resumed significant combat operations against the Seleka. By 5 December 2013, they were in a position to launch a large-scale attack on Bangui in a coordinated attempt to oust the Seleka. While this was unsuccessful, further intense conflict followed. This led to the resignation of Djotodia on 10 January 2014, the retreat of the Seleka to the north and east of CAR, and the installation, under international pressure, of a non-aligned transitional government led by interim President Catherine Zamba-Panza. 2. The organization of the parties to the armed conflict. At all material times, the parties to the conflict were sufficiently organized so as to establish the existence of a non-international armed conflict. The Seleka were a coalition of several previously uncoordinated political factions and armed groups, including 1. The Union des Forces Démocratiques pour le Rassemblement, the UFDR, 2. The Convention des Patriotes pour la Justice et la Paix Fondamentale, the CPJP-F, and 3. The Convention Patriotique pour le Salut du Codreau, the CPSK. The Seleka exhibited sufficient characteristics to established that it was an organized armed group, including possessing an ability to carry out military operations and to take and hold territory, and having significant logistical capacity. Likewise, for as long as they constituted the state armed forces, while Mr. Bozizé was president, the FACA comprised a key part of the pro-Bozizé forces and enjoyed a legal presumption of sufficient organization. While Mr. Bozizé's ouster from Bangui was a significant setback, it did not interrupt the effective functioning of his inner circle and persons loyal to him. The pro-Bozizé forces, including elements of the FACA who remained loyal to Mr. Bozizé, were reorganized to pre-existing or new self-defense groups, which came to be known as the Anti-Balaka. To any extent required, and at all times, they were sufficiently organized, as demonstrated by their maintenance of an effective command structure, their ability to carry out complex military operations, and their development of an effective logistical capacity, including to recruit new fighters. Regarding the contextual elements of crimes against humanity, Pretrial Chamber 2 confirmed that from at least April 2013 until at least November 2013, the Seleka committed a widespread and systematic attack against the civilian population in Bangui, perceived to be Bozizé supporters. The Seleka engaged in a course of conduct that involved the multiple commission of Article 7.1 acts, including multiple acts of murder, rape, torture, imprisonment, persecution, and other inhumane acts. This attack was committed pursuant to and in furtherance of a state or organizational policy to commit such an attack against the civilian population in Bangui, perceived to be Bozizé supporters. The Seleka perceived civilians with certain affiliations to be Bozizé supporters, including 1. Christians, 2. People from the ethnic tribes of the Gabaya, Manja, or Banda, 3. People living in certain neighborhoods of Bangui, 4. People who had certain professions perceived to be supportive of Bozizé, such as members of the FACA, former presidential guards who had served under Mr. Bozizé, and people close to them, and 5. People who had been employed by the Bozizé government. The attack included the multiple acts which took place at the detention facility in Bangui, referred to as the Office Central de Répression du Banditisme, Central Office for the Repression of Banditry, the OCRB. The attack further involved non-charged Article 7.1 acts that took place during other incidents in Bangui, such as an assault on 13 April 2013 on the 7th arrondissement of Bangui, a 14 to 16 April 2013 operation in the Boyrab neighborhood of Bangui, an operation in Boyrab starting on 20 August 2013, and an attack on at least 6 passengers taken from a minibus at the PK9 checkpoint in Bangui on or around 13 July 2013. The attack was systematic. The crimes comprising the attack were not committed at random. The crimes at the OCRB were 1. Planned, coordinated, and overseen by Seleka commandos, 2. Committed by the Seleka on a regular basis over a substantial period of time, and 3. Executed by the Seleka according to a consistent pattern. The attack was widespread. The attack was directed against a civilian population living in densely populated neighborhoods in Bangui, the country's largest city. The attack resulted in a large number of victims. The Article 7 acts in counts 1 to 2, 5, 7 of these charges were committed as part of this widespread and systematic attack. As a senior leader of the Seleka and an individual who was often present at the location of the charged crimes, Mr. Said knew and intended for his conduct to be part of the widespread and systematic attack against the civilian population in Bangui, perceived to be Bozizé supporters, pursuant to and in furtherance of the state of organizational policy. Regarding the common elements of modes of individual criminal responsibility, Pretrial Chamber 2 confirms that at all material times relevant to the crimes charged in counts 1 through 7, committed between 12 April and 30 August 2013, Mr. Said was a senior Seleka colonel operating in Bangui. After the Seleka's military advance and takeover of Bangui, Mr. Said was a direct subordinate of Noureddin Adam, Mr. Adam, who was the Minister of Public Security until 22 August 2013. Mr. Adam appointed Mr. Said as the de facto head of the OCRB, effectively putting him in charge of this police unit, including all Seleka who were stationed there. In this position, Mr. Said had full authority over the Seleka elements, OCRB Seleka, stationed there. In this role, Mr. Said oversaw the functioning and conditions of the OCRB detention center. Mr. Said exercised control over the OCRB Seleka stationed at the OCRB who complied with his instructions. Mr. Said provided them with supplies and ordered the arrest, detention, and mistreatment of persons targeted on political, ethnic, religious, and/or gender grounds by the OCRB Seleka. He personally participated in arrests and interrogations. Mr. Said is individually criminally responsible for the crimes charged in counts 1 through 7, committed at the OCRB between 12 April 2013 and 30 August 2013 for committing those crimes jointly with others, Article 25(3)(a), and ordering or inducing those crimes, Article 25(3)(b). Concerning the charged crimes, Pretrial Chamber 2 confirmed that between 12 April 2013 and 30 August 2013, Mr. Said, together with the OCRB Seleka, targeted perceived Bozizé supporters by arresting, detaining, and mistreating them at the OCRB. The targeted victims were 1. Predominantly Christians, 2. Predominantly belonged to the Gabaya, Manja, or Banda ethnicity, 3. Predominantly males, and 4. Predominantly from certain neighborhoods in Bangui, like Boyrab, perceived as supportive of Bozizé. These victims were targeted for arrest on political, ethnic, religious, and/or gender grounds. Mr. Said and the OCRB Seleka severely deprived, contrary to international law, these persons of fundamental rights, including the rights to life, bodily integrity, private property, freedom of movement, and freedom from torture or cruel, inhumane, or degrading treatment. The OCRB Seleka violently arrested these victims, often at night, and beat and hooded them. At the OCRB, which was an enclosed compound not publicly accessible, surrounded by high walls and guarded by armed OCRB Seleka, the perceived Bozizé supporters who were arrested were detained in small cells. Overall, the detention conditions were dire, as the detainees were held in dark, hot, cramped cells and not provided with adequate food, water, or regular independent medical attention. During the charged period, the OCRB Seleka arbitrarily detained persons who were predominantly male at the OCRB. They deprived them of fundamental rights contrary to international humanitarian and human rights law, including having access to prompt, independent review of the basis of their detention and humane treatment. While some detainees learned during their interrogations that they may have been suspected of being a fighter or a spy for Mr. Bozizé. Others were merely accused of protesting the Seleka regime, supporting Mr. Bozizé politically, or being from the Gabaya, Manja, or Banda ethnic groups. During the relevant time frame, individuals were detained in a small and overcrowded underground cell by Mr. Said's office. The OCRB Seleka, under Mr. Said's control and with his support, mistreated detainees on an almost daily basis. Mr. Said oversaw the detention of men who were beaten with rifle butts or slapped violently and threatened with death. Others were whipped with horsehide whips or sticks with metal wires, beaten with truncheons on their feet while kneeling, or with rifle butts, burnt or had their ears pulled with pliers and partially ripped off. Some men were inflicted with severe physical and psychological pain and suffering by having their hands, elbows, and feet tied together tightly behind their backs in a method called arbatachar. In line with the Chamber's instruction, I omit paragraph 29 of the confirmed charges as it contains confidential information. I will now proceed with reading the remainder of the charges. The facts referred to in paragraph 29, constituting the factual basis for counts 1 to 6, also form the underlying conduct of the crime of persecution, count 7. This conduct was committed in connection with these crimes. At the material times, Mr. Said and the other perpetrators targeted the victims who were perceived as Bozizé supporters as described above, on political, ethnic, religious, and or gender grounds. Mr. Said was aware of the factual circumstances that established the gravity of the conduct, such that it violated fundamental rules of international law, as charged in count 1. Mr. Said knew that detainees were arrested on an arbitrary basis, deprived of their right to prompt independent review of the basis of their detention, held in dire conditions, and subjected to severe physical and or mental treatment. Mr. Said knew that the perpetrators inflicted the pain or suffering on detainees at the OCRB for such purposes as obtaining information or a confession, punishment, intimidation, or coercion, or for any reason based on discrimination of any kind, count 3. Mr. Said was also aware that the persons detained at the OCRB were civilians or persons hors de combat, counts 4 and 6. Mr. Said was further aware of the factual circumstances that established the character of the acts as charged in count 5, as acts similar to other acts referred to in Article 7.1 of the statute. Regarding Mr. Said's individual criminal responsibility, Pretrial Chamber 2 confirmed the following forms of criminal responsibility. 1. Under Article 25.3a of the statute for directly co-perpetrating crimes at the OCRB. Mr. Said and Mr. Adam, Tahir Babikir, Hisene Dambucha, Yaya Sumayele, Muhammad Salet Adum Kete, Adum Rakis, Fadul al-Bachar, and other members of the OCRB Seleka shared a common plan or agreement to target perceived Bozizé supporters in Bangui by committing the crimes charged in counts 1 through 7 at the OCRB Common Plan. The crimes charged in counts 1 through 7 were committed by the co-perpetrators, including Mr. Said, and occurred within the framework and resulted from the implementation of the OCRB Common Plan. The OCRB Common Plan came into existence as soon as 12 April 2013. Mr. Said made an essential contribution to the Common Plan until 30 August 2013 by arresting and detaining perceived Bozizé supporters at the OCRB including the detention of victims in an underground cell situated by his office in the OCRB. Instructing OCRB Silica to mistreat detainees who allegedly supported Mr. Bozizé, including by tying them up using the painful abattoir method. Supplying the OCRB Silica with weapons, food, uniforms, and ID cards. Interrogating detainees violently and supporting such interrogation methods by OCRB Silica, and overseeing the overall functioning of the OCRB Detention Center, including the detention conditions, by giving instructions and orders to the OCRB Silica, deciding who could get access to the judiciary, and by reporting to Mr. Adam. Mr. Said meant to engage in the conduct described above and intended to bring about the objective elements of crimes charged in counts 1 through 7. He was also aware that the implementation of the OCRB Common Plan would, in the ordinary course of events, result in the commission of the type of crimes charged in counts 1 through 7. Mr. Said was aware that the OCRB Common Plan involved an element of criminality. He was also aware of his essential role in the OCRB Common Plan, the central nature of his contributions, as set out above, and of his ability, jointly with other co-perpetrators, to control the commission of the crimes. Two, under Article 25(3)(b for ordering crimes at the OCRB. Mr. Said ordered members of the OCRB Silica, over whom he had a position of authority, to commit the crimes charged in counts 1 through 7. Mr. Said gave instructions to his subordinates to use the abattoir method, praising this method as the best way to extract confessions. He supported other forms of severe mistreatment. Mr. Said gave instructions to his subordinates to detain men in the small, dark, and overcrowded underground cell by his office, where they were provided little food and water and no access to independent review of their detention. Mr. Said meant to engage in this conduct and was aware of his position of authority over the physical perpetrators of the crimes. Mr. Said meant for the OCRB Silica to commit these crimes and or was aware that in the ordinary course of events they would commit the crimes and was aware that this conduct would contribute to their commission. 3. Under Article 25(3)(b for inducing crimes at the OCRB. Through the conduct prescribed above at paragraph 34, Mr. Said induced the OCRB Silica to commit the charged crimes. Mr. Said exerted influence over the OCRB Silica, prompting them to commit the charged crimes. Mr. Said meant to engage in the conduct described above. Mr. Said meant for the OCRB Silica to commit these crimes and or was aware that in the ordinary course of events they would commit the crimes and was aware that this conduct would contribute to their commission. The pretrial chamber gave the following legal characterization of the above facts and held Mr. Said criminally responsible for. Count 1. Imprisonment or other severe deprivation of physical liberty as a crime against humanity at the OCRB of persons perceived to be Bozizé supporters between 12 April 2013 and 30 August 2013, including, as summarized in paragraphs 29A to R, punishable under Article 7(1)(e and pursuant to Articles 25(3)(a, direct co-perpetration, and 25(3)(b, ordering or inducing of the Rome Statute. Count 2. torture as a crime against humanity of people perceived to be Bozizé supporters who were tied using the Abattoir method between 12 April 2013 and 30 August 2013, as well as other detainees who were severely mistreated, including, as summarized in paragraphs 29B, 29E, 29H, 29M, and 29Q, punishable under Article 7(1)(f and Articles 25(3)(a, direct co-perpetration, and 25(3)(b, ordering or inducing of the Rome Statute. Count 3. Torture as a war crime of people perceived to be Bozizé supporters who were tied using the Abattoir method between 12 April 2013 and 30 August 2013, as well as other detainees who were severely mistreated, including as summarized in paragraphs 29B, 29E, 29H, 29M, and 29Q, punishable under Article 8(2)(c, subparagraph I and 4, and pursuant to Articles 25(3)(a, direct co-perpetration, and 25(3)(b, ordering or inducing of the Rome Statute. Count 4. Cruel treatment as a war crime of people perceived to be Bozizé supporters who were tied using the Abattoir method between 12 April 2013 and 30 August 2013, as well as other detainees who were severely mistreated, including as summarized in paragraphs 29B, 29E, 29H, 29M, and 29Q, as detained under dire conditions at the OCRB, punishable pursuant to Article 8(2)(c, subparagraph I and 3, and Articles 25(3)(a, direct co-perpetration, and 25(3)(b, ordering or inducing of the Rome Statute. Count 5. Other inhumane acts as a crime against humanity of people perceived to be Bozizé supporters who were detained in deplorable conditions at the OCRB, who were verbally and physically abused, including during interrogations between 12 April 2013 and 30 August 2013, including as summarized in paragraphs 29A to R, punishable under Article 7(1)(k and Articles 25(3)(a, direct co-perpetration, and 25(3)(b, ordering or inducing of the Rome Statute. Count 6. Outrages upon personal dignity as a war crime of people perceived to be Bozizé supporters who were detained in deplorable conditions at the OCRB and or were tied using the Abattoir method and or were verbally and physically abused, including as summarized in paragraphs 29A to R, between 12 April 2013 and 30 August 2013, punishable under Article 8(2)(c, subparagraph 2, and Articles 25(3)(a, direct co-perpetration, and 25(3)(b, ordering or inducing of the Rome Statute. Count 7. Persecution as a crime against humanity on political, ethnic, religious, and or gender grounds concerning the people detained at the OCRB based on the facts underlying counts 1 through 6, including as summarized in paragraphs 29A to R, and punishable under Article 7(1)(h and Articles 25(3)(a, direct co-perpetration, and 25(3)(b, ordering or inducing of the Rome Statute.
Now, thank you very much, Madam Court Officer. Now, Ms. Nori, Defense Counsel, can you please confirm that you have explained the nature of the charges? Ms. Nori, can you stand up, please? Can you please confirm that you have explained the nature of the charges to Mr. Said and his right to make an admission of guilt or to plead not guilty to the charges. Can you confirm that, please?
Merci Madame le Président. J'attendais la fin de la traduction ou de l'interprétation plus exactement. Je confirme tout à fait que nous avons discuté en détail de la teneur des charges et que M. Saïd est au courant de la teneur des charges ainsi que de son droit de plaider coupable ou non coupable. Et je peux vous informer que, évidemment, nous sommes ici aujourd'hui puisqu'il a décidé de plaider non coupable. Merci Madame le Président.
Well, thank you very much. If we can hear that from Mr. Said. Mr. Said, can you rise, please? Good morning again.
Oui, bonjour, Madame la Présidente.
Yes. Now, do you understand the nature of the charges read out to you today?
J'ai tout écouté ça, mais je plaide non coupable.
You pleading not guilty to all the charges or to some of the charges or to any of the charges?
Je plaide non coupable sur toutes les situations, sur toutes les accusations.
Thank you very much, Mr. Said. You may be seated. Can you turn your microphone off, please? Thank you. So we'll now turn to the opening statements. The prosecution will commence its opening statement today and have been allotted 4.5 hours. I know you said you'd use less time. I note for the record, in line with the directions given to the parties on Thursday, that speakers must speak slowly and observe the 5 seconds rule for the interpreters and court reporters. Furthermore, please indicate if you are shifting from one language to another. Ms. Nauri? Ms. Nauri, please. Defense Counsel. Ms. Nauri?
Merci. Pardon, je lisais le transcrit. Nous, nos plaidoiries seront exclusivement en français puisque c'est la langue de travail de l'équipe de défense.
No, I just wanted to catch your attention to what I'm saying to the court, please, to both counsel. So, furthermore, please indicate if you are shifting from one language to another to assist the interpreters and for the accuracy of the record. Mr. Prosecutor, you may now make your opening statement. Thank you.
Madam President, Your Honours, I am acutely aware that as we speak, outside of this courtroom, in the Central African Republic, and particularly in Bangui, people are riveted to their screens. I applaud the registrar of this court, Mr. Peter Lewis, and the colleagues of the registry for ensuring that there was sufficient attention given to try to help the people of the Central African Republic follow these proceedings. They have been patient, and they have shown a great deal of stamina, waiting 9 years to be able to have this trial start. I'm grateful, Madam President, to the court officer for detailing the charges and the parts of the confirmation decision and for the diligent, painstaking work of the pre-trial chamber. But the matter now is in your hands, and we're blessed to have 3 independent and impartial judges that will assess the merits of the prosecution's case, subject it to scrutiny, and decide whether or not we have proved that case beyond reasonable doubt. We say we have, and by the end of this trial, you will be convinced that in relation to all 7 counts, Mr. Said will be found guilty. Madam President, Mr. Said has entered not guilty pleas, and that is his right, and there is a presumption of innocence. But the beauty of the law is that there is no place to hide. And in the course of this trial, Mr. Said will be confronted with evidence, with witnesses that knew him, that fell into his hands or were apprehended by him, and they will speak in relation to the charges that were confirmed. As I mentioned, this has been a day long in coming. This is the first time a senior member of the Seleka has appeared before this court for trial. And the charges that are faced are really quite awful. And they are reflected to some extent in the confirmation decision. Charge of imprisonment, of persecution, torture. And these were not isolated incidents. They were, for the reasons you will hear, part of a widespread or systematic attack directed against the civilian population, and part of this attritional violence between the Anti-Balaka and the Seleka. This is the tragedy of so many countries, and it is certainly the tragedy of the Central African Republic, that these groups focused and vied for power, for hegemony, and not for the interests of the people who far too often were caught up or targeted and suffered as pawns in a greater game. The discrimination underlying the grounds of persecution will also be a feature of this case and will be elaborated upon in due course. My portion of the opening is really going to be focused on an orientation. What is the OCRB and where was it? Deputy Prosecutor Niang will then speak in French, and he will go into much more detail, followed by the senior lawyer in the case that sits behind me, Aholo McQuay. Between the 24th of March 2013 until the 10th of January 2014, for 10 horrendous months, the Seleka ruled Bangui. To say they governed would be an abuse of the English language. They ruled by diktat, by fear, by terror. And they targeted individuals that they perceived as being on the other side, not because they were, not because they were combatants, but simply because they believed they were on the side of former President Bouzizi. And Mr. Said was in charge of the location that we will zoom in and focus on in the course of this trial, the OCRB, at least between mid-April 2013 and August of that year. And he was in charge of about 35 to 60 Seleka members. And along with Mr. Yahya Somaili and Mahmoud Tahir, his voice determined the fates of so many individuals. He brought people to the OCRB. He did not protect them, but rather he actively participated in their capture, hunting them down, and subjecting them to the most dire conditions that he could conjure up. Although a de facto leader, Mr. Said wielded immense power. And in fact, in that area, and definitely in the OCRB, he was only ahead of him was Mr. Nuruddin Adam. Madam President, perhaps if we can go to evidence 2 on your monitors, we will show a map of Bangui, and you will see there in red the OCRB is marked, and along with that are the locations of other incidents that you and the members of the public will hear in the course of this trial. To the north we have the 7th arrondissement, to the northeast. Above that we have Boy-Rabe, which has 2 incidents detailed in April 2013 and August 2013. To the west, we have an awful incident, executions at the PK9 minibus incident, and they were then taken to the river and thrown dead, and their bodies, some of them were recovered, but they were certainly photographed. And then we have Sedad, not too far from the OCRB. But if we move to the next photograph, Madam President, you will see an aerial shot of OCRB. You will be able to make out perhaps a larger building towards the north of the picture and outhouses. And if we move down from the air, we will then see the gate of OCRB. This was the outside world's view, people that were passing. This is what they saw. A pre-existing base used by the Seleka for criminal purposes in the prosecution's respectful submission. And Madam President, if we look at the video in front of you in a few moments, you will see a compilation that's been put together by the Office of the Prosecutor's Forensic Section from missions in 2016. This shows the inside of the compound, and first of all, you will see the main office building to your left. To the right, you will see some other cell buildings, including towards the southeast, which are marked on the video G5 to G7. These are cells in which men were detained and subjected to what the prosecution says was grotesque abuse. And right across from the OCRB building, there's another cell block, which includes 4 more cells, which you can see labeled G1 to G4. Around the whole perimeter is a high wall, and if we keep moving, Madam President, we'll come to the gate that you see now on the right-hand side of the picture, and we started with a picture from the other side from the road in which OCRB was emblazoned upon it. If we go, with the help of Ms. von Braun, to the main building, we can go inside. And inside this main building, Mr. Said had an office. And perhaps we can go into that office. Because in that office, he controlled the whole of the facility. And what is more, literally under his feet, he put civilians in a space called the hole. in that hole, civilians were kept in really putrid conditions, filth around them, their own feces, stale air, lack of ventilation, treated not as humans, not even as animals, a class below. Their humanity apparently eviscerated by the policies and action of the accused that faces trial in these present proceedings. There they were not given water. There was no due process. They were cut off in every sense from the protection of the law. And those victims come to this court and will come before your honours to have their rights vindicated, to have a determination underlined that what took place was wrong, it was illegal, and it was against the provisions and the protection of the Rome Statute. I would ask that we can play the video. And this is taking your honours into the hole. 9 witnesses will give evidence in the course of these proceedings about what it was like to be down in that space where the air was rank, stale and stinking, with a lack of ventilation, given the number of people that were crowded together. You will hear them speak about having to sit in feces, the bucket they were given overflowing, rats running around. And this dump, this hole away from the light of legality, is not the only place where these poor souls were kept. 6 other cells were above ground. We've shown those from outside. But the conditions were similarly dire, so bad in the heat, emaciated and thirsty, compelled to drink their own urine to quench the thirst in such a deprived and unnecessary manner. And I'd ask that we could also play the video of one of those rooms. This is room cell G3. When the door is closed, it is dark inside. And you'll hear witnesses saying that it was so crowded, they couldn't even lie down. Madam President, the courtyard that you're looking at was not a safe haven. Witness after witness will testify that they came out from those cells, not for fresh air, but for beatings. Beatings with all kinds of instruments, gun butts, whips, to make that not inconsiderable pain cut even deeper. Witnesses will describe having their backs covered in mud or soil or gravel, so that the lacerations would go deeper and the whips would cut more effectively. Madam President, you will hear, and Your Honours, what the court officer mentioned regarding the abachacha method, a singular design of tying a person's hands and elbows and feet together behind their back in a way that strains every ligament, causes agony, not just discomfort, and left so many with partial paralysis, temporary paralysis, and numbness. And these wounds cut deep indeed. You will see some photographs in a moment. But what the photographs do not tell is what perhaps Your Honours will hear in the course of this trial. The psychological effects of that treatment, which can be just as profound as the physical cruelty and torture the prosecution allege Mr. Saeed committed against these individuals. Many remain traumatized today. Many can't move in the manner they could before they fell into the hands of Mr. Saeed, the Salaka, and his henchmen that were in charge of OCRB. At least 16 people were tied in the Arabacha method. One example is P547, and God willing, Your Honours will hear his testimony soon. You can see with the naked eye the deep lacerations into his arms. The Arabacha seared his flesh, and years later, it is all too apparent. Marked for life, because the prosecution allege Mr. Saeed did not intervene, did not protect, did not lift a little finger to use any iota of his authority to alleviate their suffering. Rather, he deliberately exacerbated it in many ways that he could. P547 lived to tell the tale, and his voice, Madam President, represents other victims who were beaten and tortured at the OCRB and not photographed. They will tell you about the mental anguish and the pain and the distress that they feel today. Now, the prosecution alleged that Mr. Saeed was not a passive spectator, not simply somebody who failed to prevent and repress and punish, but he actively hunted down civilians himself and brought them to the OCRB, knowing exactly what he had planned for them, what nightmare awaited them under his control and custody. For example, P3053, P3056, P3064 will all testify about being apprehended not by unknown individuals, but by the person who is in the dock, brought by himself. And also, you'll hear evidence from the prosecution that Mr. Saeed also ordered the arrest and detention of Mr. Oswald Sons and 2 other men who were detained in the OCRB. And you'll have evidence also that the OCRB, with that high wall and the perimeter and the forbidding gate, was guarded by Salaka members with heavy weapons. People couldn't escape, even if they were not hamstrung with the Arabacha method. This was no office to repress banditry. This was no location to assess any criminal conduct. This was a torture center, designed as such to spread terror, hardship, and pain. The evidence comes from many sources. And Madam President, Your Honours will hear not just from victims and survivors, but from insiders, people that worked with Mr. Saeed, that saw his actions, that can testify to his presence at the OCRB, such as P2105, P2161, P2563. You'll hear evidence of relatives. Imagine that. Awful to be tortured without the protection of the law. And when some have managed to find out sniff out where their loved ones have been taken. Imagine the desperation because of the state of the unknown and knowing what was happening in that period. And you'll hear evidence from P2241, P2692, P3053, P3064, P3056, that they were forced to pay what was for them enormous sums of money to the accused and the co-perpetrators mentioned in this case to obtain the release of their loved ones. A bit of profit, perhaps, on the side of the cruelty that was being committed. And the evidence will show powerfully that the accused at no time disciplined any of his subordinates with respect to what he saw, the degrading treatment, the ill treatment of the people that were there in the OCRB. As I mentioned earlier, Madam President, figuratively and literally, below the room in that hole, Mr. Said had his feet on the heads of his fellow brothers in Bangui. But little surprise, perhaps, the prosecution allege that he didn't prevent or punish, because P338 will testify that Mr. Said told him himself the Batacha method was the best way to secure confessions. Mr. Said's crimes, alleged by the prosecution and confirmed by the pretrial chamber, were not isolated or spontaneous acts, but were committed as part of a widespread or systematic attack and constitute crimes against humanity. He knew, Mr. Said clearly knew, and had knowledge that his own conduct formed part of that wider attack, because he also took part in those wider attacks. Madam President, one of the features of this case is the discriminatory nature of what took place. When the Seleka took power on the 24th of March 2013, ousting President Francois Bozize, the evidence will show that with no finesse, with no attempt at discernment or distinction, individuals with certain attributes were targeted because they were deemed a threat to the Seleka. They were targeted on political, ethnic, religious, or gender grounds, sometimes these intersecting grounds as well. Christians, Faka, presidential guards, ethnic groups such as the Baya, the Manja, and the Banda. Sometimes it's enough just to live in a certain locality, like Boirabe. You were perceived, those unfortunate souls were perceived by dint of their residence, where they had managed to find a home, to be supporters of the previous regime. And Madam President, you will hear evidence of the attacks on the neighborhoods of Boirabe, where men, women, and children were killed. Women and girls were raped. Men and boys arbitrarily arrested, and houses systematically looted. After these attacks, the hospitals of Bangui were full of the injured. And on the picture before you, Madam President, you'll see a photograph taken by a journalist, witness P342, an individual being brought to the hospital. Some of the fruits of the Seleka efforts. Weird fruit, as the song goes. Strange fruit, as the song goes. Mr. Said knew about these attacks and the policy as he was a senior member of the Salaka and was in a position of authority directly subordinate to the Minister of Public Security, Mr. Nuruddin Adam. And witnesses will testify that he took part. Mr. Said himself took part in some of these attacks. He looted goods himself and brought them from Boy Rabe back to OCRB himself, looting to go with the cash for hostages, cash for prisoners release that we have already spoken to. In April 2013, the Salaka attacked the 7th arrondissement, looting and killing, and you'll see another photograph, P312, who will testify in these proceedings, God willing, a civilian, escaped with his life by the narrowest of margins. The wound itself shows how fortunate he is to be alive. And in July 2013, 6 to 8 men were taken from a bus at PK9, if you remember the first map, towards the west of Bangui, and brought to Camp Daru, executed in fact, and thrown in the water. We can see those individuals floating, not just corpses, but beloved sons or children to those whose families they belong to. This is not easy for the people in Bangui to watch. It's not easy for them to hear. But the reason we have trials and we have due process is to separate specious from the truth. And it's our belief that in the course of this trial, the truth will out. And those that are responsible for this, and Mr. Said himself, will have a chance to answer as to why he says he's not guilty. But we assert in any event that the evidence will show that all 7 counts are proved beyond reasonable doubt. The Salaka didn't bring peace. They brought misery. And in the course of this opening, in fact it will be the part led by senior trial lawyer Hola McQuay, you'll also see a variety of the evidence that the prosecution has in terms of testimonial and documentary evidence, including military reports and email communications, that will demonstrate beyond reasonable doubt the responsibility of Mr. Said. You will see identification cards that Mr. Said issued bearing his own initials. He was a man of great power. How unfortunate it is for the people of the Central African Republic. How unfortunate it is for Mr. Said that he didn't use that authority, that power, properly and humanely, but instead abused his own people. Madam President, on the 28th of July 2022, the arrest warrant for Mr. Nuruddin Adam, the former Minister of Public Security and second in command of the Salaka, was unsealed. Mr. Adam, of course, was the immediate superior of Mr. Said. It's only right to use this opportunity, with your leave, to reiterate the importance for justice that the warrants issued by this court and by judges of this court are executed in a timely manner, because victims have a right to the truth. At the same time, this office that I have the honor to lead has been trying to work more closely with the special court in Bangui, to give further dynamism to the spirit of complementarity. We will endeavor to deepen that so that there is more justice and the evidence that my office has collected can find a home in independent courts wherever that is possible. But for today and at this moment, the eyes and the focus is on Mr. Said and what he did and what he chose not to do. With your leave, at the end of this opening speech, and certainly by the end of this trial, I am convinced when you've heard from the opening of Deputy Prosecutor Niang and the senior lawyer in the case Holla McQuay, you will have a much better picture of the strength of the prosecution evidence and why we say with confidence that this is a case that you will be able to be convinced about beyond reasonable doubt, that Mr. Said is responsible and did commit all 7 counts that were confirmed in these proceedings. Thank you so much. And with your leave, Madam President, perhaps I can pass the floor to Deputy Prosecutor Niang.
Thank you very much, Mr. Khan. Mr. Niang, I note you have like 12 or 13 minutes more. Would you want to start your own part of the opening speech?
C'est vous qui nous guiderez, Madame. Si vous estimez qu'il serait plus sage de commencer après la pause aussi, je pourrais être guidé par votre direction, Madame la Présidente.
Thank you very much. I'm just looking at the time. Okay, you may start now. If it's 11 o'clock and we are not done, when we come back after the break, you could continue. Thank you. Carry on, please.
Merci, Madame la Présidente, Madame, Monsieur les juges. C'est avec humilité, mais avec un profond sens du devoir que je me présente pour la première fois devant vous ce matin. Et c'est avec une égale humilité que j'ai l'honneur de prendre la parole à la suite de Monsieur le procureur Karim Khan, Conseil de la Couronne, qui vous a déjà planté le décor avec une très grande illustration. Je présenterai le dossier, Madame le Président, de l'accusation contre M. Saïd au cours peut-être de 40 à 50 minutes, pas plus. En tout cas, je n'irai pas au-delà du temps qui nous a été alloué, parce que la Chambre a déjà reçu un exposé détaillé dans le mémoire de première instance qui vous a été soumis par l'accusation. Aujourd'hui, je m'attacherai donc à présenter les aspects saillants des éléments de preuve que l'accusation présentera et qui constituent les faits essentiels de l'espèce, les faits permettant d'établir les éléments constitutifs des crimes et les modes de responsabilité. L'accusation prouvera, au-delà de tout doute raisonnable, que M. Saïd est coupable des crimes qui lui sont reprochés. Et cette responsabilité pénale est recherchée à titre individuel pour des crimes de guerre et des crimes contre l'humanité qui ont été commis à l'Office central de répression du banditisme, dont vous avez déjà vu toutes les images, et qui va par son intitulé en français l'OCRB, et tout cela dans cette période de temps entre le 12 avril 2013 au moins et le 30 août de la même année. L'accusation s'appuiera sur un ensemble d'éléments de preuve variés pour prouver le bien fondé de sa cause. Elle produira des témoignages, comme le procureur Khan l'a déjà annoncé, mais pas seulement que des témoignages, il y aura aussi de la preuve documentaire, des images vidéo et des clichés d'imagerie numérique qui établiront sans conteste la culpabilité de l'accusé. Les éléments de preuve seront aussi apportés par les témoins de l'intérieur, qu'on appelle aussi plus communément les témoins initiés. Donc, parce qu'ils ont vécu avec l'accusé une partie de ce qui a été fait, à savoir donc des personnes qui étaient présentes à l'époque visée par les charges et qui ont connu donc de l'intérieur les actes et la conduite de l'accusé et de ses subordonnés. Madame la Présidente, Madame le juge, Monsieur le juge, au cours du procès, vous entendrez des témoignages poignants des victimes qui ont souffert aux mains de l'accusé, M. Saïd, et de ses co-auteurs, dont certains vous ont déjà été indiqués par le procureur Khan. Madame la Présidente, Monsieur le juge, Madame le juge, j'évoquerai tout d'abord les faits établissant le rôle et la responsabilité de M. Saïd à l'OCRB. Donc l'OCRB est dans les crimes qui ont été commis. Avant d'aborder les éléments de preuve étayant les éléments constitutifs des crimes de guerre et des crimes contre l'humanité. Nous allons d'abord commencer par le rôle de Saïd à l'OCRB. M. Saïd est visé par les 7 chefs d'accusation suivants que vous voyez sur l'écran. Donc le chef 1, c'est l'emprisonnement ou une autre forme de privation grave de liberté physique en tant que crime contre l'humanité. Le chef 2, torture en tant que crime contre l'humanité. Le chef 3, torture en tant que crime de guerre. Chef 4, traitement cruel en tant que crime de guerre. Chef 5, autre acte inhumain en tant que crime contre l'humanité. Chef 6, atteinte à la dignité de la personne en tant que crime de guerre. Et chef 7, persécution en tant que crime contre l'humanité. Madame la Présidente, Madame, Monsieur le juge, l'accusation fait valoir que M. Saïd a perpétré ces crimes conjointement avec d'autres personnes au sens de l'article 25.3a du statut de Rome et qu'il a ordonné ou encouragé ces crimes au sens de l'article 25.3b du statut. Les éléments de preuve qui seront présentés démontreront que M. Saïd, membre de haut rang de la coalition Seleka, a été à la tête de ces éléments de Seleka et des opérations de l'OCRB à l'époque visées par les charges, à savoir entre avril et août de l'année 2013. Le 12 avril 2013, aux environs de cette date, Noureddine Adam, dirigeant Seleka de haut rang et ministre de la Sécurité publique, a nommé l'accusé chef de l'office, donc de l'OCRB. Cette nomination est survenue peu de temps après que la coalition Seleka a pris le contrôle de Bangui et que le président Bozizé, déchu, a fui le pays. Au poste qu'il occupait, M. Saïd avait pleine autorité sur les éléments Seleka qui suivaient ses ordres, comme le procureur l'a indiqué tout à l'heure, et comme le démontreront les éléments de preuve que nous soumettrons au cours de ce procès. Il supervisait le fonctionnement quotidien de l'OCRB, ainsi que les conditions de détention qui y étaient appliquées et la gestion des personnes qui y étaient détenues. Non seulement Saïd supervisait et commandait les Seleka de l'OCRB, mais il leur fournissait aussi les moyens, il leur fournissait l'argent, il leur fournissait d'autres moyens nécessaires comme la nourriture, les uniformes et même les armes. Il leur ordonna également d'arrêter des personnes, de les placer en détention et de leur infliger les mauvais traitements. Des éléments Seleka et des policiers affectés à l'OCRB, à l'époque visés par les charges, viendront ici pour en témoigner. Lorsqu'en avril 2013, les Seleka ont pris la direction de cette structure qu'est l'OCRB, cet endroit était déjà un centre de détention de la police, dont les cellules servaient à enfermer des détenus dans le centre de Bangui. Vous entendrez des témoignages selon lesquels pendant plus de 4 mois, l'accusé a rempli ses cellules avec les personnes qu'il arrêtait et détenait arbitrairement. Et vous avez déjà vu effectivement des photos relativement parlantes et qui reviendront au cours de ce procès. Des témoins attesteront que le complexe était entouré de hauts murs d'enceinte et qu'il était quasi impossible de s'en échapper. Ou en tout cas, pour y échapper, il fallait le faire avec de grands risques, y compris au péril de sa vie. Madame la Présidente, Madame le juge, Monsieur le juge, des personnes qui ont survécu au crime reproché et certains de leurs auteurs témoigneront que l'OCRB avait 6 cellules en surface. Elles vous sont présentées sur les photographies qui ont été affichées à l'écran par le procureur Khan. Les Seleka y ont détenu des prisonniers durant de longues périodes et comme vous pourrez le constater sur la prochaine diapositive, ces cellules étaient exiguës et dépourvues de fenêtres. Outre les cellules de détention en surface, une cellule souterraine, communément appelée le trou, donc, qui vous a été montré tout à l'heure, donc, qui servait à détenir d'autres prisonniers. Elle se trouvait, là aussi comme on vous l'a indiqué, sous le bureau de l'accusé. Et le procureur Khan a utilisé une image très parlante en parlant que sous ses pieds, sous les pieds d'Adam, donc il y avait ces détenus. Donc, à cet endroit, de nombreuses victimes ont été détenues par les Seleka de l'OCRB dans les conditions les plus effroyables et les plus inhumaines, qui soient pour des êtres humains, privés des droits les plus fondamentaux et des garanties de procédure régulière. Il n'était bien entendu pas facile de pénétrer dans ce qu'on appelait le trou. Le témoin 2400 viendra attester qu'il a dû sauter dans la cellule souterraine parce qu'il n'y avait pas de descente harmonieuse, parce qu'il n'y avait même pas de marche, il fallait sauter. Il vous dira qu'une odeur d'excréments et d'urine se dégageait de la cellule, qu'à l'intérieur, il y faisait sombre et froid et que le sol était recouvert de détritus. Dans les cellules de l'OCRB, les éléments de la Seleka, sous le contrôle de M. Saïd, détenaient des personnes considérées comme favorables à Bozizé, des chrétiens, des membres de certains groupes ethniques, pris pour cible, tels que les Gbaya.
Mr. Niang, maybe this is a good time to stop and so that we can adjourn and come back at 11:30 for a short break. Okay?
D'accord, Madame la Présidente.
Thank you. Madam Court Officer, can we adjourn till 11:30, please?
All rise, we will be.